This is a video reviewer for the Philippine Bar Examination. This is Bar Exam Reviewer number 1, featuring questions on criminal law, general principles. There are 10 questions featured in this reviewer. All questions are modeled on actual questions that appeared on previous Philippine Bar exams. Before you proceed, please don't forget to subscribe to Review Central and click the bell icon to make sure you are notified of all new reviewers and other important updates. Let's begin. Question number 1. State the characteristics of criminal law and explain each. Note, this question is a bar exam favorite. It is known to have appeared in several bar exams, including the 1978, 1982, 1988, and 1998 bar exam, among several others. Suggested answer. The characteristics or cardinal principles of criminal law are as follows. 1. Generality. That the law is binding upon all persons who reside or sojourn in the Philippines, irrespective of age, sex, color, creed, or personal circumstances. 2. Territoriality. That the law is applicable to all crimes committed within the limits of Philippine territory, which includes its atmosphere, interior waters, and maritime zone. Article 2 of the Revised Penal Code. 3. Prospectivity. That the law does not have any retroactive effect, except if it favors the offender unless he is a habitual delinquent or the law otherwise provides. Article 22 of the Revised Penal Code.
Question number 2. What are the different schools of thought or theories in criminal law? Describe each briefly. To what theory does our Revised Penal Code belong? Note, this question is known to have appeared in the 1996 bar exam. Suggested answer. There are 2 schools of thought in criminal law, and these are: A. The classical theory, which simply means that the basis of criminal liabilities is human free will, and the purpose of the penalty is retribution, which must be proportional to the gravity of the offense, and B. The positivist theory, which considers man as a social being, and his acts are attributable not just to his will but to other forces of society. As such, punishment is not the solution, as he is not entirely to be blamed. Law and jurisprudence should not be the yardstick in the imposition of sanction. Instead, the underlying reasons would be inquired into. We follow the classical school of thought, although some provisions of eminently positivist tendencies, like punishment of impossible crime, juvenile circumstances, etc., are also incorporated into our code.
Question number 3. The American consul accredited to the Philippines while driving his car recklessly and imprudently along Rojas Boulevard bumped a pedestrian who was crossing the street, and the latter died as a consequence of his injuries. Prosecuted in court for the crime of homicide through reckless imprudence, the consul claimed diplomatic immunity, alleging that he is not subject to Philippine laws and regulations. Is his defense tenable? Why? Note, this question is known to have appeared in the 1975 bar exam. Suggested answer. Under the principle of public international law, only sovereigns or heads of states, ambassadors, ministers plenipotentiary and ministers resident, enjoy diplomatic immunity. Consuls do not enjoy immunity from criminal prosecution. Refer to Republic Act No. 75, and Schneckerberger v. Moran, 63 Phil 250.
Question number 4. After drinking 1 case of San Miguel beer and taking 2 plates of pulutan, Binoy, a Filipino seaman, stabbed to death Siomai, a Singaporean seaman, aboard MV Princess of the Pacific, an overseas vessel which was sailing in the South China Sea. The vessel, although Panamanian registered, is owned by Lucio C., a rich Filipino businessman. When MV Princess of the Pacific reached a Philippine port at Cebu City, the captain of the vessel turned over the assailant Binoy to the Philippine authorities. An information for homicide was filed against Binoy in the Regional Trial Court of Cebu City. He moved to quash the information for lack of jurisdiction. If you were the judge, will you grant the motion? Why? Note: this question is known to have appeared in the 2000 bar exam. Suggested answer. Yes, the motion to quash the information should be granted. The Philippine court has no jurisdiction over the crime committed, since it was committed on the high seas or outside of Philippine territory, and on board a vessel not registered or licensed in the Philippines. Refer to U.S. v. Fowler, 1 Phil 614. It is the registration of a vessel in accordance with the laws of the Philippines, not the citizenship of her owner, which makes it a Philippine ship. The vessel, being registered in Panama, is governed by the laws of Panama while it is in the high seas.
Question number 5. When can a Filipino citizen residing in this country use an alias legally? Give 3 instances. Note: this question is known to have appeared in the 2006 bar exam. Suggested answer. There are actually more than 3 instances when a Filipino citizen residing in the country can use an alias legally. You can cite any 3 of these. 1. Pseudonym for literary purposes. 2. Use of aliases in cinema and television entertainment. 3. In athletics and sports activities. RA 6085. 4. Under the Witness Protection Program, a person may adopt a different identity. RA 6981. 5. When he has been baptized or customarily known by such alias. 6. When authorized by a competent court. CA number 142, as amended by RA 6085. 7. When properly indicated in a certificate of candidacy. Omnibus Election Code.
Question number 6. Abe, married to Liza, contracted another marriage with Connie in Singapore. Thereafter, Abe and Connie returned to the Philippines and lived as husband and wife in the hometown of Abe and Calamba, Laguna. Can Abe be prosecuted for bigamy? Note: this question is known to have appeared in the 1994 bar exam. Suggested answer. No, Abe may not be prosecuted for bigamy since the bigamous marriage was contracted or solemnized in Singapore, hence such violation is not one of those where the revised penal code, under Article 2 thereof, may be applied extraterritorially. The general rule on territoriality of criminal law governs the situation.
Question number 7. Penal laws define distinct classes of crimes. Discuss and elucidate on their distinctions. Note: this question is known to have appeared in the 1978 bar exam. Suggested answer. In general, penal laws refer to the revised penal code and special laws. Crimes punished in the revised penal code are called felonies, and those punished in special laws are called offenses. A felony as a rule is an act mala in se which is wrongful from its very nature, while an offense is an act mala prohibits, which is a wrong only because of the law punishing it. The revised penal code also classifies felonies as intentional, if dolo or malice is present, and culpable, if there is culpa or fault. According to gravity, felonies are grave, if the penalty is capital or afflictive in any of its periods, less grave, if the penalty in its maximum period is correctional, and light, if the penalty is arresto menor or a fine not exceeding 200 pesos, or both.
Question number 8. What are the limitations upon the power of Congress to enact penal laws? Note: this question is known to have appeared in the 1988 bar exam. Suggested answer. The limitations upon the power of Congress to enact penal laws are as follows. 1. Congress cannot enact an ex post facto law. 2. Congress cannot enact a bill of attainder. 3. Congress cannot provide for a cruel punishment. Also, other limitations may be considered like: Congress cannot enact a law which shall punish for a condition. Congress shall punish an act and not the condition or status. Robinson v. California.
Question number 9. Antonio is the defendant in a civil case being tried in the Manila Regional Trial Court. Together with his lawyer, Antonio went to Singapore to take the deposition of a witness who, Antonio hoped, would support his defense. The deposition was taken in a function room of the Singapore Hotel before Mr. Abante, the Philippine Consul General. Neither plaintiff nor his counsel attended the proceeding. After the deposition taking, Antonio, not satisfied with the results, persuaded Abante to make substantial changes in the transcripts of stenographic notes. Antonio offered $5,000 in Singaporean currency which Abante readily accepted. Elizabeth, vacationing daughter of Abante, was given $200 by Antonio when she made the alterations in the transcripts. The deponent, with neither notice nor knowledge of the alterations, signed the deposition. May Antonio, Abante, and Elizabeth be prosecuted in a Philippine court for offenses punishable under our revised penal code? What are the offenses, if any? Explain. Note: this question is adopted from a question which is known to have appeared in the 1986 bar exam. Suggested answer. Insofar as their offenses are concerned, under the revised penal code Abante committed bribery and Antonio corruption of a public official. Elizabeth committed falsification of a public document as a principal by direct participation and Antonio as a principal by inducement. Article 2, Revised Penal Code. However, only Abante can be prosecuted before a Philippine court. Being the Philippine Consul General in Singapore, as a public officer, the provisions of the revised penal code can be given extraterritorial application, as the crime committed by him is related to the duties of his office. Antonio and Elizabeth, being private persons, cannot be prosecuted before a Philippine court regarding the offenses committed by them, because the provisions of the revised penal code cannot be given extraterritorial application.
Question number 10. Article 2 of the Revised Penal Code states that the provisions of the said code shall be applicable to crimes committed not only within the territorial jurisdiction of the Philippines, but also outside thereof, in the 5 instances mentioned therein. What are the underlying reasons behind, or rationale for, each of those 5 instances? Explain fully one by one. Note: this question is known to have appeared in the 1982 bar exam. Suggested answer. The 5 instances provided in Article 2 of the Revised Penal Code, in which its provisions are applicable outside the territorial jurisdiction of the Philippines, and the underlying reasons behind each of said instances are the following. 1. When the offender should commit an offense while on a Philippine ship or airship. For this exception to apply, the Philippine ship or airship must be registered under Philippine laws. As such, it is considered an extension of Philippine territory. 2. When the offender should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the government. The reason is to protect Philippine currency notes and obligations or securities issued by the government in order to preserve the financial credit and stability of the government. 3. When the offender should be liable for acts committed with the introduction in the Philippines of obligations and securities mentioned in paragraph 2. The reason is to protect the economic interests of the Philippines, as the introduction of such forged or counterfeit obligations and securities into the country is as dangerous, if not more, as the forging or counterfeiting of the same. 4. When the offender, while being a public officer or employee, should commit an offense in the exercise of his functions. The offense committed by the public officer affects the integrity of the office and is against public administration of the Philippines. The law should follow the public officer wherever he may be. If such is not punished by the laws of the country where the public officer is at the time of its commission, or is not triable by its courts, the absence of this exception would not make the provisions of the code applicable, since the crime is committed outside of Philippine territory. 5. When the offender should commit any of the crimes against the national security and the law of nations. The reason is to safeguard the existence of the state.
References and attributions. The questions featured in the preceding reviewer were adopted from 2 documents, namely 1. Answers to bar examination questions in criminal law arranged by topic, 1975 to 2003, edited and arranged by Jeanette Logie Ecow and Alex Andrew P. Ecow, Silliman University College of Law, which in turn was based from the answers to bar examination questions in criminal law by the UP Law Complex, July 26, 2005. And 2. Answers to bar examination questions in criminal law arranged by topic, 1994 to 2006. version 1973 to 2003, edited and arranged by Jeanette Logie E. Cow and Alexandru P. E. Cow, Silliman University College of Law, and updated by Don D., which in turn is based from the answers to bar examination questions in criminal law by the UP Law Complex and Philippine Association of Law Schools, July 3, 2007. Both documents have been expressly declared as freeware by their creators. This reviewer has been prepared and presented by Review Central solely and entirely for educational and reference purposes. No copyright infringement intended.
You have just completed watching the Philippine Bar Examination, Reviewer Number 1, featuring questions on criminal law, basic principles. Check out more related review videos and playlists on our channel. If you find this useful, please like and share. Leave a comment to share your thoughts or questions regarding this reviewer or any particular part of it. If you haven't done so yet, please subscribe to Review Central and click the bell button to get notified of all future reviewers and updates. Like and follow us on your favorite social media platforms. Good luck to your forthcoming bar exam, and we look forward to your long and fulfilling career as a lawyer and legal professional in the Philippines.